The type of retention that may be necessary in one city may be different in another given its peculiar needs. The other benefit about having things handled at the local level for these issues, it will allow for a fluid and ease of readjustment as necessary. I want to reiterate that PORAC is fully supportive of the use of body-worn cameras to be used and implemented responsibly. And one item that I have not addressed, which I'll leave to everybody else, is the cost, which will be significant if not substantial. I thank you, and I remain available for any questions.
And I would like to say we really appreciate, Mr. Fishman, that PORAC is making specific suggestions. Have you given those over to our committee staff now?
They have.
Yes. Oh, great. No, it really will help if we have a starting point that you suggest. Mr. Ingmanson also would appreciate any specific interests that the Los Angeles Police Protective League has as well.
Yes, we submitted a bullet point and a statement to you.
Great.
Hopefully you have.
All right. Mr. Bibbring, could you particularly address the comments here by Attorney Fishman and Ingmanson, as well as whatever specific items you came ahead to here to talk to us about?
Certainly, and there are definitely a number of points on which the ACLU and the Police Protective League and PORAC agree, which may be surprising to some people, but we do.
I'm very glad to hear it. It will make our job much easier.
So let me start in thanking this committee and members and Mr. Chairman. Body-worn cameras, in the end, are a surveillance technology, and too often surveillance technologies are deployed by local police departments without the careful thought about the privacy implications and the right balance between public safety and privacy that is being given by this committee here today. Decisions about when data can be collected, who has access to it, when it's released to the public, what kind of security measures are in place to protect that data. And let me start by noting that one of the most basic protections for privacy that can be implemented at a local level is to require local departments to put in place a clear policy on body-worn video before body-worn video is deployed. And actually, that's a requirement that is true of any surveillance technology, from license plate readers to drones or other kind of video surveillance. As a starting place of our agreement with the former speakers, the ACLU recognizes that body cameras are a tool, and they hold great promise. The initial studies are promising, and as Mr. Chairman, you recognized earlier, while it's not clear that those results will translate across every jurisdiction, from large urban departments to small rural departments, they are promising. But how those tools use the policies that are in place determine whether they will be effective, less effective, or actually undercut the values of accountability and transparency that they're meant to promote. And I should start by noting that although the ACLU is certainly supportive of body cameras, there are community groups in Los Angeles that for whom the privacy concerns actually outweigh the potential public safety benefits, and have been on record as opposing body cameras because of concerns that they will be used as a surveillance tool, that the video will be used to exonerate officers but withheld when it is incriminating. And so I think it's also important to recognize that there is a diversity of viewpoint in the state. I'll start by focusing on privacy issues per the subject of this panel. And by indicating that the first stage of privacy concerns is at the recording. What events can be recorded? And with respect to officers, it's the position of the ACLU, and certainly the weight of case law in the courts, that officers don't have a privacy interest in their interactions with the public while they're on duty. But that doesn't mean that there are no privacy concerns raised by body cameras, as the former speakers indicated. The ACLU certainly favors mandatory recording of most, if not all, interactions with members of the public. There are certainly narrow exemptions that can be made for sensitive situations, certain child victims of sexual assault, for example, or even private places like recording in the home. But in order to ensure accountability, permission to turn off the camera should be obtained in advance and obtained on camera wherever possible. Also, with respect to recording, notice should be provided to people wherever practical that video is being recorded. Obviously, that can interfere with the course of an investigation, so simply labeling a camera with a plaque that says that the interactions will be recorded could achieve some of that purpose. Obviously, surreptitious recording is more invasive than open and public recording, and so that privacy concern can be addressed easily. And also, informing civilians that they're being recorded helps further the deterrence value of cameras in de-escalating situations. People will behave less aggressively, as the Rialto study shows, when they know they're being recorded. A second area of important privacy protections has to do with the limitations on use and access by the department to video. Departments should access video only for a handful of specified reasons. First of all, when there's some reason to believe that there is misconduct or criminal acts captured on the video, either with an officer from a civilian complaint or some kind of a use of force that has triggered an investigation, or where there's civilian conduct that's criminal in nature captured on the video. Also with respect to randomized audits to ensure that training is being followed, or corrective action if an officer is required to be monitored. An officer should be able to be required to be monitored through video if there's a history of problems and that monitoring is part of a corrective action plan. One of the areas where we agree completely with the Protective League is with respect to a clear ban on fishing expeditions, whether it's the officer that Mr. Ingmanson referred to earlier that was essentially subjected to a fishing expedition where supervising officers went through hours and hours and hours of video looking for minor violations, or civilians, if there's a protest against the mayor's policy, that video shouldn't be subject to review after the fact for minor violations that might be charged. And in fact, policy should go further and bar any review absent either outside of a randomized audit or a particularized suspicion. Certainly, video should not be used to build dossiers or gather information on members of the public. For example, at that hypothetical protest of a mayor's policies. Last, the issue of public access to video is a crucial one, and one where obviously the values of transparency and public access to government information are in tension with privacy. I do want to make the point, transparency is not the same as accountability here. A police department can have a well-functioning disciplinary system, but if it's not transparent, if everything is hidden from public view, the public may not have confidence in that disciplinary system. In the end, if police departments keep video secret, the public, some segments of the public will believe that they are doing that because there's something to hide. And it's particularly important that there be meaningful access to public video. Now, there are a couple of issues here. I mean, one is a legal issue. As this panel has already heard, there's some ambiguity in the interpretation of the investigative records exemption to the PRA in Government Code 6254F, so that some departments believe that a great deal of the information must be disclosed, and others believe that a great deal is properly withheld. But I would point out that the investigations exemption isn't intended to balance privacy and transparency, and in fact sets up perhaps the wrong incentive structure or the wrong result, where incidents where there's the highest public interest, where there's a police-involved shooting, for example, are unquestionably going to be the subjects of investigation, and so those would be withheld, whereas incidents with the lowest public interest, where people are requesting video of why the police were out to their neighbor's house or what happened when their spouse was stopped for a traffic stop a few weeks ago, that those would not be withheld under the investigative records exemption. And so there may be legislative work to be done to tailor the Public Records Act to the right balance between privacy and transparency. From a policy perspective, it is crucial that there be public access to those records, to video, particularly of critical incidents. And there are a few approaches that various jurisdictions have taken that are worth calling attention to. There's the blurring that Professor Eberhardt mentioned that Seattle has implemented and in fact is available for viewing as of yesterday. It's not clear that as a technical matter that is going to obscure privacy sufficiently to obscure the video sufficiently to protect privacy while allowing enough transparency to really understand what is going on. There is case-by-case review, of course, as is currently happening in Oakland, where officers are reviewing the video, but it's not clear that, obviously that's time-intensive, resource-intensive, but it's also not clear that there's a legal basis for withholding video that is highly private other than the catch-all exemption of the PRA. One solution that has not been addressed that I want to call attention to is the potential to release video only to individuals who appear on that video, and that would allow those individuals to make a decision about whether their privacy interests are implicated and justify withholding the video, or whether it could be distributed if there's some potential misconduct. A mandatory release of video to people who appear on the video or at least have a significant interaction with an officer would not necessarily waive the rights of the department to withhold under the Public Records Act, because disclosures required by law do not waive exemptions. And then finally, the Public Records Act could be redrawn to allow release of certain categories or to mandate release of certain categories. For example, critical incidents where there is a use of deadly force or allegations of serious misconduct. In closing, I wanted to address one issue that's outside the privacy concern, and that is the issue of, because it's come up several times today, the issue of officer access to video footage before making a statement. I want to be clear. The ACLU strongly opposes that, and I think that significantly undercuts the accountability justification of cameras. Both the LAPD publicly and here today has said that they don't want to release video to the public because it might taint investigation. That rationale applies equally to the officers involved. And nobody's saying that the officers shouldn't be allowed to view the video and to respond to the video, but before they make a first statement, in order, as Chief Wentz said earlier, to capture the officer's state of mind rather than what he or she has seen on the video, it's crucial that that the officer make that first statement before reviewing the video. That's particularly true where nobody else is given access to the video before they make statements.
All right. I'm hoping you're finished with
Yes.
your testimony. You went a little bit over. What you said is a lot less clear than what I've heard from attorneys Fishman and Ingmanson. If you don't allow fishing expeditions, which I would agree is at least expensive and perhaps not appropriate, how then can you release video, and what would constitute a fishing expedition rather than simple release to the public? It's just not at all clear to me.
Well, I think particularly the public has the strongest interest in access to video where there is an incident involved and where there's certainly a critical incident, but other allegations of misconduct. Any of those would qualify as not a fishing expedition because there's reason to believe that there may be misconduct, whether that's because there's an allegation of misconduct or there's an incident that has happened that triggers a mandatory investigation.
But you've also said under those circumstances it's an investigation, so it would not necessarily be released.
Well, as a descriptive matter of what the current state of the law is, that may be true, and my point is that is not well matched to balancing privacy and public
okay. So
access
you would,
concerns.
in these highest profile incidents, you would call for release of the video?
Unquestionably, and there may be some time delay that's required, a minimal time delay that's required to allow the initial investigative steps, but absolutely the video should ultimately be released. And that shouldn't be left to the vagaries of the court process, because court cases can settle and videos can remain.
I'm sure we'll have some interesting discussions on that. Assembly Member Alejo and Vice Chair Melendez, do you have some questions? You're good? Alejo? All right. Thank you very much. Excellent. Again, Attorney Bibbring, if you've gotten specific proposals to our public safety staff as the PORAC and LA Police Protective League have done, that would be very helpful to us.
Thank you. We've submitted some materials already, but I will circle
Great.
back.
Thank you. All right, so our fourth panel will explore the implications of body cameras on litigation. We'll hear from attorneys Morgan Ricketts. Morgan Ricketts is right here. Good. David Mastani, who will also discuss civil litigation. David. And then Attorney Jeffrey Toma, the President of the California Attorneys for Criminal Justice, who is sitting now. And then finally, Paul Hora, Assistant DA from Alameda County, will talk about issues in criminal cases. So perhaps we could hear first from attorneys Ricketts and Mastani.
I apologize. Could you repeat that?
Excuse me?
Okay.
And if you could keep your comments to about 5 minutes, that'd be great.
Yes. My name is Morgan Ricketts. I'm a proud member of the Consumer Attorneys of California and the National Police Accountability Project. Thank you very much to the committee for inviting me to speak today. I reviewed some of the questions that the committee wanted to address, including instances where the body camera footage is not mentioned in the police report, and when the footage is provided to criminal defendants or civil litigants. And I think that there are some other questions that might be a little bit more interesting from a litigation perspective. Are there times when the body camera footage is not mentioned?
Could you move your microphone closer to you? That way we'll be able to hear you better. Perhaps put it on top of your papers. I'm not sure. Or, well, we'll just, here, someone will help.
How's this?
That's much better.
Okay. So are there times when the body camera footage is taken but not mentioned in the police report? I think it's hard to say. There's not a lot of body camera footage in Los Angeles that I've encountered, but the responsibility is on the defense attorney or the civil litigant to engage in discovery and to find out if there is body camera footage. I think that even if it's not mentioned in the police report, that's our responsibility, and we'll find it if it's there, assuming that the police organization is turning it over. When the footage is given to the criminal defendant or the civil litigant, again, it just depends on whether discovery is requested. So to me, that's the first problem, that many of these cases, in particular criminal defense cases, they're being pled out. People are pleading out. They're not doing discovery. So they're not necessarily finding out if there's a video, and if so, what the video is saying. That's a big concern of mine, and I would advocate for allowing, setting up some kind of system to allow criminal defense attorneys to remotely access the video that's going to be tagged related to their incident, to their client's incident, even before discovery is requested, so that they can have the opportunity to preliminarily determine, is this a case that deserves a little bit more of a closer view, or is it a case that just needs to be pled out and move on? The committee asked about chain of custody issues. I can't personally speak to that. I haven't had any issues with chain of custody. Hopefully somebody else on this panel will. I would like to address the having officers view the footage prior to making their reports. As a civil rights litigator, in a deposition, you always ask the deponent what their memory is of the incident before you show them the documents. If it's a critical issue. If it's not important, of course, you can just show them the documents. But I always get their story first, and then I show them the documents and see if there's a conflict with their story. And I think that's going to be a critical tool that you're going to take away from criminal defense attorneys and from civil litigants if the police officers are the first ones to look at the video and they can see the video before they make their report. And I do agree that memories are not perfect, and so there may be some need for the officer at some point to view the video and make sure they're not missing anything to correct something that they might have mistaken. But they should be required to first make a statement and admit, hey, I don't remember what happened exactly at this point, or I believe that this was what happened and then this other thing happened, prior to being able to view the footage. Because if their memory or their impression of the event is different than what actually happened, that's really important from a civil litigation or a civil rights perspective, and it's also very important from a criminal perspective. The other thing I would advocate is we should adopt a missing video presumption to address possible manipulation by police officers. We've seen a lot of incidents where there was a use of force or a fatal use of force, and the camera happened to not be turned on. There was a glitch in the camera. There was something happened where the video was not available for the victim or for the criminal defendant to use. And the only way we can really address this effectively is to have a missing video presumption where if the police department's policy says that there should be video taken and there's no video available, then there's a presumption in favor of either the criminal defendant against whom charges are being brought or the civil litigant. I think that's all I have for now. And in terms of personnel records, the final issue that I'll talk about, there needs to be very careful attention given to when a video is going to constitute personnel records. Obviously, if the officer's in training and he's receiving training on the video, that might be a time when it could be considered a personnel record, but it really shouldn't be something used to shield video from either the public or the criminal defendants or civil litigants. Thank you.
Thank you. Attorney Mastani?
Thank you.
You may.
David Mastagni, I'm also a member of the Consumer Attorneys and the American Association of Lawyers for Justice. But we also have, here in Sacramento, the largest law enforcement representation firm in the country and in California. These issues are eminently present in a lot of the litigation that we're currently doing. What I would agree that on number one, there really isn't any data to say whether or not an issue exists of not turning body cameras on. It's still in the field testing stage. It's just we're not ready there. With regard to when defendants are given the discovery in criminal cases, there are penal code sections, there's discovery, and I'll defer to Mr. Hora to my right. He probably knows them by heart. I generally know it's like 1054 of the penal code, and that when a decision to prosecute's been made, that's available and that there are certain protections of witnesses. When it comes to civil litigants, you really have to break that into two categories. The pre-litigation civil litigants, which are going to be CPRA, and there's going to be a lot of litigation on the issue of the media. And corollary to the whole CPRA issue is attorney's fees and who is going to be chilled from seeking the release or non-release. For instance, victims and witnesses have really no power over the release or non-release. That's something that's up to the entities, and so some kind of standing has to be afforded to those people, and they need to be exempt from having attorney's fees assessed against them. If I'm an ordinary citizen and I'm a witness and I'm fearful that the release of my information is going to jeopardize me or somehow chill me from wanting to going forward. I want to be able to contest public access to that video without the specter of attorney's fees being assessed against me. And I'm aware of cases so far at the trial level where non-public entities who have no power over the actual release or non-release who have contested have had attorney's fees assessed against them. So I think that you're going to, with regard to the civil cases, you've got the 2030 sections of the Civil Code, and those are going to determine when documents are released. And I can think of hundreds of situations where motions are going to be made, truck accidents where there's fatalities, auto accidents, various disasters of kinds where law enforcement is there. Most civil litigators are going to say, okay, I see what the responding officer reported in the police report, but we know that sometimes that's not 100% accurate. We know it's not going to have voice inflections. We know that there's video out, so you're going to have a significant amount of litigation over access in civil cases. I hardly believe that the insurance industry is going to pass on not being able to get the actual statements, nor frankly, if I were representing an officer, I would want to see the footage. I respectfully disagree with my colleagues who have taken the position that officers should not be afforded access to the videos because, after all, we want truth and accuracy. We don't want to trap people down the line in testimony based upon recollection or recall. I don't have to go into my own experiences or anyone else's. Your recall is just better, and that mechanism is addressed under the evidence code, where you can ask the witness, is this your actual recollection or is it refreshed from something? And that never fails to be asked in a deposition or other discovery forum. You're going to have litigation not only over fees and costs on the CPRA, you're going to have litigation with the media because they're going to want access to these records for reasons unrelated to law enforcement. They're going to want them because it's a notorious person or myself, let's say, or a politician or somebody. They're going to want to see the footage. So that's going to be litigation. I've discussed the privacy litigation of citizens. It's going to be HIPAA. It's going to be the type of crime investigation. It's going to be safety. It's going to be access to the criminal justice system free of intimidation, that someone's going to see that it's you who talked to the police, and that type of issue. Then you're going to have search issues, like what the camera filmed on an entry into a structure. You're going to have search issues on what the camera filmed that was something you weren't there for. Those are going to be issues. You're going to have issues in domestic violence cases where the camera is going to be relevant. It's going to possibly be litigated in the bargaining context, the extent to which the impacts are bargainable, the extent to which implementation is bargainable. Those are potential litigation issues. You're going to have it on restraining orders outside of the context of domestic violence. But I think what most of all this is going to do, it's going to eliminate litigation in this specific context, where someone is charged with a crime, and we know from our experience that one of the ways to defend a case is to say there's officer misconduct of some type. Then that develops into a who said what, and it affects the prosecutorial decision of whether or not to prosecute, whether to plea bargain. And I think a net effect of this is that it will be a law enforcement tool which will result in decisions to prosecute. It'll affect decisions to prosecute. It'll affect decisions to take pleas. And it may, depending on and much of this is open to speculation because we don't know, but it may increase the number of prosecutions. The DA may say, hey, the witnesses are saying this, but the video camera shows that. Hey, the witnesses are saying this and the video camera shows that, and it may result in either a plea, a decision not to prosecute, or a decision to prosecute. That's open and up in the air.
Perhaps if you could take like one more minute, although I love your testimony, but we have to get through here, so.
Okay, the exemption for investigation is going to be a subject matter of litigation. I hardly see the press corps accepting that as I'm leaving town. And there's going to have to be some development of standing, who has standing, not penalize the citizenry for objecting to their private interests being exposed. It certainly will come forward to some extent or another in administrative cases. And there's liable to be litigation over retention, how long, what's retained, when it's on, when it's off. There are a whole host of issues, and I hope that I have been helpful to this committee. I can only tell you that these issues arise all the time without videos, and so they're going to arise not just on the video footage, but on the audio footage as well. And those are issues to be taken into consideration in implementing and how to implement.